Okay, I'm back. This is the third and final video in the Commerce Clause lectures. It's March 16th. No, it's March 21st, 2016. And we left off with Lopez. So we're shifting PowerPoints. So this is the third PowerPoint that I sent you, and that's on NYU classes. And on the first slide is the modern era, 1994 to 2012. So we're going to cover Lopez, Morrison, Reich, I think that's how it's pronounced, and Sebelius, the Affordable Care Act case. So again, the Lopez case is kind of a strange case because what it's actually about is not much. It's kind of a silly law. Some people call it a grandstanding law. Congress can say, look, we're doing something even though they're not. But in terms of legal doctrine, it turns out to be quite significant. Again, it's the first time the court strikes down a law of Congress that's grounded in the commerce power as beyond Congress's commerce power since 1937. So from 1937 to 1994, the court didn't do this. In Lopez, it does it. It's a good set of facts. If you're going to assert that there's a limit, I mean, this is a powerful case in which to do that. So what's at issue in the case? So I'm on slide number 1 on the third PowerPoint. Something called the Gun-Free School Zones Act of 1990. And in this act, Congress made it a crime to have an illegal handgun in or around a school that is in a school zone. School zone is within 1,000 feet of a school or in a school. Federalizes the crime. Lopez is apprehended in a San Antonio high school. He's got a gun, he's got bullets. He could be prosecuted under state law. I guess in theory, if we federalize it, we might make the punishment more certain or more severe or something. I don't know. But he's handed over to the federal government, and he defends himself by saying, you know, where does Congress get the power to do this? And Congress's answer, as it always is the Commerce Clause. And in a 5-4 decision, the court strikes this provision of the law down. And hold on just a second. I don't want to stop the video and start the video again because I can't stop it and start it. I can only do a new video. All right, got my notes. The opinion appears on page 378 of the Bretschneider text. And after describing the facts of the case, Rehnquist gives us this sort of opening, this bold proclamation, right? We start with first principles. And the idea is the national government is still a government of enumerated name defined powers. Federalism is important. States are important. The federal system prevents tyranny, it protects liberty, it enhances democracy. And next he says, well, we know we've expanded national power vastly over the course of the 20th century, but this power is subject to outer limits. It's certainly true, as I said before, that no prior decision fails to assert that there are limits. We're just not sure what they are. And it's also true, he says, we have adhered to the rational basis test. We do give Congress every benefit of the doubt. And then he makes a couple of moves that matter for the rest for the rest of the way. First, he says we have 3 big categories that we've allowed Congress to proceed under its commerce power. First, Congress can regulate the use of the channels of interstate commerce. Second, Congress can regulate the instrumentalities of interstate commerce or persons or things in that commerce. And third, we've let Congress regulate activities that have a substantial relation to or a significant effect on interstate commerce. It's only this third rationale that matters in this case in Morrison, in Reich, and in Sebelius, right? Just this substantially affecting commerce rationale. And this law, this Gun-Free School Zones Act, can only be justified under this third rationale, that there's some connection between possession of the handgun in or around a school and the health of interstate commerce. So at this point, he makes the most controversial move that we want to pay attention to on page 380, right? And he introduces the idea, or asserts the idea, that the nature of the targeted activity is crucial, that it makes a crucial difference. And specifically, he says, where economic activity substantially affects interstate commerce, legislation regulating that economic activity has been upheld, right, and will be upheld. I'm paraphrasing, but this is the idea, that there's a big difference. If what we're regulating is economic, presumably refusing to rent a room to somebody on the basis of race, then you can target that activity. But if it's non-economic, then it's a much different question, and we're not ruling out the possibility that it could reach non-economic activities, but we're going to be much more skeptical about that. If the move makes sense, then the court can strike down this law without overruling the many cases in which it's upheld Congress's power, right? Doesn't have to overrule any prior cases. But does the move make sense? So a couple of questions here about the move, this distinction between the target being economic versus non-economic. One, does he have the history right? Do the prior cases really turn on, and can they be explained by this distinction between the targeted activity being economic or non-economic, right? Was Filburn's production and consumption of wheat on his farm economic or non-economic? It wasn't yet a commodity. He wasn't selling it. Is that economic activity? Well, it's a potential commodity, so maybe it is, maybe it isn't. What about Ollie's Barbecue and its refusal to serve blacks at its restaurant? Is that economic activity or non-economic activity? Ollie's restaurant was a business. That's true. Did the courts in those prior cases discuss and base its decisions on a distinction between economic or non-economic activity? And more broadly and fundamentally, even if you could decide on the distinction, what's economic, what's non-economic, the bigger question is, why should it matter, right? I mean, the liberals' response to this is, it doesn't matter. The point is the effect on commerce. It doesn't matter what you call the activity. What matters is Congress's claim that there's a connection to interstate commerce or national markets, and that's what justifies the regulation. Couple of minor points that are going to make a difference going forward. I'm asking you to think about reasoning from case to case in these four cases. How are they factually different? How are they factually similar? Do they comport with each other? Can they be reconciled? I mean, maybe Reich comes out in favor of national power, but it's consistent with Lopez and Morrison because the facts are significantly different, right? So I'm asking you to think about reasoning in law here. So it makes sense for me to talk a little bit about these sort of tangential issues that are going to matter if we're thinking in that way, if we want to evaluate what the court is doing in that way. So I've moved to, I'm sorry I'm not pointing out the slides to you, but I'm now up to slide 4. You might have wondered what Chief Justice Rehnquist meant when he said that this law, this Gun-Free School Zones Act law, contained no jurisdictional element. That simply means that the law could and would be on firmer ground if it did contain a jurisdictional element. That would mean that you'd have to show in each particular case that that particular gun had moved in interstate commerce, and then Congress might say, well, we're trying to intervene in interstate markets in illegal guns, and so if there is that jurisdictional element, the law would be more likely to be upheld. There isn't one in this case, and that makes Congress's argument weaker. You might have wondered what he meant when he said Congress made no explicit findings of fact. Well, sometimes when Congress legislates in this area, it does make a record. It tries to make a factual case and to state the courts in a way, state the facts in a way the court might state them, to justify the claimed nexus between the regulated activity and interstate commerce. And this is a difference with Morrison. There are no factual findings in Lopez, but in Morrison, for the Violence Against Women Act, Congress, held many hearings and made a huge record, and it makes for fascinating reading about the extent and depth of violence against women in this country. The same 5 justices didn't buy Congress's argument there either, but it's a difference. In Lopez, Rehnquist then turns to the government's claims about the nexus. What does the government have to say about the connection between illegal possession of a handgun in or around a school and interstate commerce? And I've specified these on slide number 5. There are 2 broad claims. One is guns lead to violence, and violence obviously has economic costs. Violent crime discourages travel. Why travel? Well, that's what we said about the Civil Rights Act and racial discrimination. So that's one argument: guns, violence, and the cost of violence. The second argument is guns around schools interfere with the educational process, and interfering with the educational process harms interstate commerce. I don't know. Whatever. Use your imagination. And Rehnquist's response, which it's kind of hard to argue with. The argument in favor of the law has to be an argument about deference to Congress and the democratic process, writ large. Rehnquist's response is that if these rather attenuated linkages and claims about these linkages are good enough, then there's no limit. Congress can reach anything with these kinds of chains of reasoning, and that's not our system. And it also seems to matter, there's an intimation that another thing going on here, and this is slightly different than it's economic versus non-economic. Possession of the gun is non-economic. That matters. This is slightly different, and that is that this seems to intrude on an area that's traditionally left to the states, namely criminal law. Does it override criminal law? It does kind of substitute for a state criminal process in this case. And that's a concern. So that might be another kind of variable or factor. Is Congress wading into an area that we've traditionally left to the states, like family law or education law or criminal law? Justice Breyer writes the main dissent, and he's joined by Stevens, Souter, and Ginsburg. And he opens with his own sort of 3 generalizations about Commerce Clause jurisprudence. First, Congress can reach any local activity if it has a significant effect on interstate commerce. Second, Congress, we've always allowed, since the New Deal, allowed Congress to take aggregate effects into account, not just the impact of one instance. And third, we judge at one remove. Deference has been important here because we have had difficulty, before the New Deal, we had extreme difficulty maintaining these logical categories, right? And we lack the expertise that Congress has to make judgments about policy, so we bend over backwards to defer to Congress's judgment. We just ask whether a sane person could think these things were connected, and then he goes on to say why he's a sane person, and he thinks there are possibly some connections between possession of a gun and interstate commerce. So we should uphold the law. It's interesting that no prior cases are overruled. Breyer would stand on the idea that some kind of substantial constraint can come from the democratic process. I'm not sure how we would investigate the truth or falsity of that claim. I think it comes down to your normative preferences about the idea of limits and the importance of federalism, but we'll get back to that in a minute. The claim for the majority in Lopez has to be that the non-economic versus economic distinction tells us what's different about Lopez. I don't see how that's different than loan sharking, although again, loan sharking, money, business, loans, credit, I don't know. Maybe there's a stronger case for that. After Lopez, Congress does amend its law to include that jurisdictional element, and the lower courts say, okay, fine, if this is what you're doing, it's upheld. So again, people say, well, Lopez is much ado about nothing, the law is trivial, it lives on in a different form anyway, who cares, right? But Lopez has a lot of potential in terms of ideas about national power and federalism. And I do think that there is something implicit in the majority about federalism that's important to think about, right? That they believe that reviving federalism limits on national power is an important project and maybe one, more faithful to the original constitutional design, and we should nudge back toward that understanding. I think the economic, non-economic distinction, as Justice Souter will say in Morrison, is kind of a cover for that theory. Now, we could agree or disagree with Souter about the suitability of that theory or the whether it's an archaic one, but we should see it, right? The concern about federalism is, the whole federalism debate. Are we better off in terms of freedom and democracy when the states have more rather than less autonomy? And here is this idea of traditional local concerns. Again, you have to sort of figure out how to interpret what that means in the modern world and whether to hang on to it, right? But that understanding of federalism is, I think, the real motivation for the specific argument in Lopez to strike down the law. So that brings us to slide 7 and the Morrison case. Now, there's more at stake here. There's a lot more at stake here. It's on page 386 of your book, case decided in 2000. And in Morrison, the defendants are Antonio Morrison and James Crawford. They challenged the constitutionality of a provision of the Violence Against Women Act, or VAWA, V-A-W-A. This is a law passed and signed into law in 1994. The text of the relevant legal provision is on page 387 of the Bretschneider book, and what it does is it creates a cause of action and the possibility of civil damages for gender-motivated violence. And it says that victims of gender-motivated violence, Congress clearly has domestic violence and sexual assault in mind, can sue their attackers in federal court. This is not a criminal statute or a criminal proceeding. No one's going to jail. The burdens of proof are a bit different, but they could get civil damages, right? Monetary relief and injunctive relief. Gender-motivated violence in the law is defined as based on animosity, based on gender. Congress might reason that there are lots of possible defects or gaps in state criminal justice procedures. There are biases. We do protect defendants' rights, and that's a constant tension when we're talking about sexual violence. The rights of criminal defendants, the presumption of innocence, the need to prove guilt beyond a reasonable doubt, problems of evidence that are particularly acute in this area, the discretion that police have, that prosecutors have. All of that could lead Congress to say, well, it's a problem, it's connected enough to interstate commerce, and we want to supplement, not supplant, available remedies. This doesn't displace the criminal justice process, it just adds an additional remedy. So that's a wrinkle in the case, that it isn't really substituting for state criminal justice processes, it's offering an additional avenue of redress. But where in the Constitution does Congress get the power to address this problem? And here, unlike in Lopez, Congress invokes two main sources. It's the same two that we saw in the Civil Rights Act cases. The Commerce Clause is I think, the main one, and the more substantial or stronger one. But also, Congress says we have the power under the 14th Amendment to protect people's basic rights to bodily integrity and liberty and equality. And Section 5 lets us pass legislation in furtherance of protecting those 14th Amendment rights. But here again, Antonio Morrison is not the state of Virginia. He's not a state actor, so we run into that same problem. So we have a student at Virginia Tech. I'm on slide 8. Her name is Christy. I'm not sure how to pronounce her last name. Brancala, I believe. And she alleged that she was, in September of 1994, raped by Morrison and Crawford. They're both members of the football team. It's very early in her first semester in September. And she says she's raped in the dorm room by both of them. And in the lower courts, we get more detail about what happened. But she's traumatized. She doesn't tell anyone for several months. She tells a friend in early 1995. But then she's decided that, she's not even going to go to the police. She doesn't really have any evidence, and she doesn't want to go that route. But she does file a complaint within Virginia Tech's internal disciplinary process, right? It does have a policy. Policy, by the way, about sexual misconduct wasn't widely publicized, and this is something Morrison can rely on later, that, notice of the policy. So there is a hearing within the university. The panel finds there's not enough evidence against Crawford. Finds that Morrison, was guilty of something. At the hearing, he said, she said no twice, and yeah, I went ahead anyway, but it was, basically consensual. He denies that it's a violent assault. She says it is a violent assault. And the university suspends Morrison for 2 semesters. Now, at that point, Morrison lawyers up, and he goes at the university, and he has some claims, that this isn't due process for me, and I'm going to sue you, and it's not fair. And the university then reconsiders. It holds a second hearing. It finds him guilty of a violation again, but as it goes up the chain of university command, right before the fall of 1995, it says, well, the penalty that we gave him the first time is too severe. He can come back now, just in time for football season. They don't tell Brancala, and, she finds out about it, not from the university, and she drops out of school. But then she sues all of them. She sues Morrison, Crawford, and the university under this provision of VAWA to get a civil remedy. And Morrison defends the lawsuit by saying that this provision of the law has a lot to it. A lot of the law gives money to localities or agencies to do anti-rape work or whatever. But this provision of the law exceeds Congress's power under the Commerce Clause. And the court's decision in Morrison is 5-4, and we have the same lineup as in Lopez: 5 justices to strike down this provision, 4 justices to uphold it. And Rehnquist's argument can be summarized pretty quickly. I'm on slide 10. This is Lopez. Lopez controls this case. This case is just like Lopez. The lawyers say it's on all fours with Lopez. The law can only be valid as a regulation of an activity that substantially affects interstate commerce. It's not an economic activity. It's a matter that's traditionally left to state criminal law, and there's no way that sexual assault is economic activity, right? Now here, Congress has made massive findings about the damage to the national economy and interstate commerce that flows from sexual violence. So, to me, if the factual case matters, then the factual case here is just way stronger than the factual case in Lopez for the linkage. But as in Lopez, the targeted activity, they're not themselves economic. And the findings, that's true. Congress has made these findings of facts, but Rehnquist's answer is the usual one, to attenuate it, right? And they are long sort of causal chains to interstate commerce. Loss of employment, loss of wages, healthcare costs, all kinds of costs, right? Sexual violence hurts commerce in various ways, but they're the same kinds of arguments proffered in Lopez, right? And again, he's saying if this argument will do, then there won't be any limits. Congress will be able to reach into criminal law, family law, education law. Where's the limit if this is okay? Rehnquist then turns to the claim that Congress has the power to do this legislation under the 14th Amendment. The government knows it has the state action problem here, so it tries to make what I would call a default argument, that if the state government is kind of defaulted on a good response to the problem, then Congress can step in to protect these basic rights that people have that the state can't take away. So inaction becomes the action, or inappropriate or ineffective action becomes the action. The court doesn't buy it, and it sticks with this Civil Rights cases rule from 1883 that you have to have state action, and what Morrison is doing is not state action. And I think there the majority is likewise concerned that a different reading of the state action requirement would radically alter the balance between the national and the state governments, right? Justice Thomas concurs. He writes to add his view that we should go back to the pre-New Deal understanding of all of this. And I want to take a couple minutes actually, I'm on slide 13 now, to talk about Justice Souter's dissent, because it's interesting, because he gives an interpretation of what he thinks the majority is up to in these cases, in Lopez and Morrison. And he opens with a flat rejection of the meaningfulness or the coherence of the economic versus non-economic distinction. That is the targeted activity economic or non-economic? And then he says, Congress has the power to legislate with regard to activity that in the aggregate has a substantial effect on interstate commerce. The only question in this case is that true of sexual violence? And obviously he would conclude that it is. Could Congress rationally conclude that it had a substantial effect? Not do I think it does, but could Congress rationally come to that conclusion? Yeah, we think it could. It's not about the wisdom of the policy or the effectiveness of the policy. It's about whether a sane person could think there was a connection. That's the doctrine pre-Lopez. And he notes and makes a lot of the mountain of data, he calls it, that Congress amassed to try to show that connection. So on his view, racial discrimination and gender-motivated violence are kind of like the same. It's the same kind of argument that supports the exercise of the commerce power in both areas. Or similarly, in Wickard, we could have labeled Filburn's homegrown wheat non-economic, certainly non-commercial. So on page 393 of your text, Souter hints at another factor or variable that might explain the majority's line drawing, and this is whether the target activity is traditionally a matter of state concern or local concern, as we've said before. And again, in this case, you could say that it's a supplement, not a substitute for state activity, right? This is an additional remedy. So does it interfere with something that the states are doing or have the power to do? No. So that's important to him as well. So that's his critique of the majority's reasoning in the case. But then, again, I'm still on slide 12 and 13, summarize Souter's argument. he steps back and he says, so why? What's really going on here? If it doesn't make any sense on its own terms, and that's his case, then what are they up to? And he makes an analogy. He says the pre-New Deal court had these logical distinctions. In that case, it was manufacturing versus commerce or direct versus indirect effects on commerce. It used those distinctions to pursue a philosophical commitment to laissez-faire political economy, right? That it had an idea about political economy and the line between government and the economy. And those logical distinctions, which were really blurry and didn't hold up, but they were useful to pursue this vision of the good, which was limited government and free market arrangements, right? Similarly, he says, it's not a commitment to laissez-faire economics, but a commitment to federalism that is driving these logical distinctions. Here, it's economic versus non-economic. So it's incoherent distinctions, but they're in service to the pursuit of a conception of federalism. He calls it the federalism of some earlier time, snidely. All right, well, does our agreement or disagreement with the court in Lopez and Morrison, does it turn on, you know, A, whether we embrace that vision of federalism, and why, and B, is it for the court to police it? Is it the court's role to say that these are constitutional limitations that can be elaborated and enforced by the court? The liberal argument cannot mean we abolish federalism. I mean, that's not really true to our constitutional tradition either. It must mean that it's better, we're better off if the courts kind of stay out of it and leave it to the political process. So when we turn to the next case, on slide 14, Gonzales and Reich, we get a surprising turn back toward the support of national power, and the facts are different. But it's a fascinating case. This is one of those cases where the justices, particularly for the conservative justices, the justices' substantive normative commitments. In this case, I don't like pot, and I don't like medical use of marijuana because that might be the thin edge of a wedge to make it more normal, and it turns out, in retrospect, to be kind of maybe true. I don't like making an exception to use pot as medicine. But I do like state autonomy, and I don't like overreaching national power. So those two ideas are in conflict in this case, and I think that this is what allows Justice Stevens to get Justices Kennedy and Scalia to agree with him. This is a 6-3 majority to uphold a federal exercise of power and override a state law that's directly in conflict. I imagine most of our sympathies are with the state law, but that's really not what the game that Stevens is playing here. So in Reich, we have a federal drug enforcement agency raiding the houses of users of pot for medical purposes in California in conformity with the California Compassionate Use Act of, I think it's 1996, and they get to grow it and use it in their homes under California state law. And the Bush administration, Gonzales is Alberto Gonzales, wants to raids their house and takes their pot, and this is federal law. You can't do this under federal law. And one of the claims of the claimants, not the only claim, but the main claim, is Congress doesn't have the power to reach this activity under the commerce power because it's not economic. You know, I'm growing pot in the privacy of my home, and I'm smoking pot in the privacy of my home, and I have terrible pain from cancer, and that's what I'm doing. And where does Congress get the power to come into this domain? It's a domain of state law, but the people of the state have spoken. This is legal in the state of California. If we follow the logic of Lopez and Morrison, then shouldn't those cases prevent the federal government from overriding California's decision? Justice Stevens, who dissented in Lopez and Morrison, puts together a 6-justice majority. And and thereby upholds the federal power, right? And this is a, sort of a doctrinal turn back to supporting the court's Commerce Clause jurisprudence pre-Lopez, right? Stevens' opinion for the court offers, and you got to be careful about this, right? It's artful. A distinction between, and I've put this on slide 16, so if you want to read it, an economic class of activities in the aggregate that have a substantial effect on interstate commerce, and intrastate activity that is not itself commercial. An economic class of activities that have a substantial effect on interstate commerce versus activity that's intrastate that is not itself commercial. Well, what Lopez was doing and what Morrison were doing, those are intrastate activities that are not themselves commercial. Obviously, right? Possessing a gun, committing a rape. So by using the phrase class of economic activities to describe the regulated activity in this case, growing and using pot in conformity with state law, Stevens arguably is trying to bring his analysis within the law as articulated by Lopez and Morrison. The claim is, well, okay, I can't overrule Lopez and Morrison. Those are law, and presumably the 5 justices who agreed as a majority in those cases are still there, and so I can't get their vote. But I can say this case is different, significantly different factually, such that it should come out differently compared to Lopez and Morrison, right? This case is different because it involves a law, a federal law, regulating an economic class of activities, even though the conduct is not itself commercial, right? So it's not like Lopez or Morrison, which both targeted non-economic activity and interfered with state criminal law. But this case is just like Wickard and Filburn, regulating the arguably non-commercial activity, growing wheat for home use, growing pot for home use.
Call from Solar America.
If
Call from Solar America.
That's a call from Solar America. If Congress must do that in furtherance of its regulation of an interstate market in a commodity, right? Homegrown wheat and homegrown pot for personal use are not commodities, but they easily could become commodities. So the logic of congressional regulation is kind of the same. The pot overhangs the market. Congress here wants to eradicate the market. It's permissible. May not be wise, but it's permissible to do this because it's tightly connected to an admitted power to regulate the interstate market in pot by eradicating it. So in any event, the Federal Controlled Substances Act, as applied here, is constitutional. So I think what he's doing, and the additional point is that we have a direct conflict between federal law and state law. When we have that, Article 6 of the Constitution contains a supremacy clause. Federal law trumps. Now we should note, because you might be troubled, like this is kind of immoral, taking away somebody's medicine when they're in excruciating pain. Stevens does note that they have a different kind of claim, a rights claim, that they may have some basic liberty, autonomy, dignity claim under the 14th Amendment that would apply to the national government under the 5th Amendment. But the lower courts didn't rule on that, so he's not addressing that here one way or the other. They may have some other claim that would protect them. But Congress has the power under the Commerce Clause to do this. On page 400, I'm on slide 18 now. On page 400, we have a significant excerpt from Scalia's concurring opinion, and he has some interesting thoughts to add on this whole issue. He says, implicit in the whole discussion has been the necessary and proper clause, right? That's part of the picture of any claim about a local activity substantially affecting interstate commerce. that we have to think more clearly about means-end rationality. And here, the means-end rationality, you have to do this in order to do something we admit you have the power to do, makes more sense, right? The idea of a potential commodity overhanging the market. So he writes to talk about that, and that's a difference with Lopez and Morrison, he thinks, in this case, right? Congress can reach it, whatever we call it, if it has that connection as necessary and proper to an admittedly valid system of regulation of interstate commerce. The principal dissent in the text comes from Justice Thomas, and O'Connor and Rehnquist are with him. And it's simple. The conduct at issue in this case is local. It's not about interstate markets. It's local. So local, it's in the home. And it's non-commercial. And under Lopez and Morrison, Congress cannot reach it. Right. And then just a final point about the impact of the case. On the day it's decided, you could imagine federal agents raiding houses all over the country. But that's not what happened. The Obama administration is not interested in enforcing it. More and more states pass medical use statutes of various kinds. 4 states have legalized it. So again, it's sort of the justices jockeying to shape, understand, determine the doctrinal thrust. And the next case really is a huge case, right? It matters a great deal. So we're up to the Affordable Care Act case, and I'm at 41 minutes on this one. So, okay, there are going to be 4 videos. The Affordable Care Act case will get its very own video, and I'll be back in a minute.